Svoboda, well known to many of us, he focuses on civil litigation and human rights. He's the founder and executive director of Attorneys for the Rights of the Child, a non-profit organisation addressing the illegality of involuntary genital surgery in Berkeley, California. Steve.
Can everybody hear me okay? Yes? No? Right. Well, before I forget, the very first thing I'm going to say is thank you to John Geishecker, Lon Griffiths, Georgianne Chapin, and Amber Craig, all of whom contributed ideas to my talk. It's called 3/4 for Abnormal, Misha's Case, 6 Societies and the Law. So before I came out here, my 6.5-year-old son Eli asked me what I was doing here. And I said, oh, Daddy's going to a conference to talk about some medical procedures. Well, what medical procedures? And I said, well, there are some medical procedures that Daddy doesn't think it's a good idea to do on people that they still do on some people. And so I'm going to talk about that to the group. And I realized that I don't even want him to know that this goes on. It's not good enough that it doesn't happen to him. I don't even want it to be known that it's happening to anyone. The transformational power of genital mutilation must be appreciated to understand these practices' persistence. A 19th century physician's medical article stated in all seriousness that fully 3/4 of all male babies have abnormal prepuces. S.G.A. Brown, 1896 to 1897. 3/4 of all male babies have abnormal prepuces. Interesting. Such a redefinition of normality is inherent in the process of genital mutilation, and indeed can be one of its goals. Genital mutilation can promise to turn a boy into a girl into a boy, an intersex person back into either a girl or a boy, depending on what's desired, a non-virgin back into a virgin, a woman of average appearance into a beauty, or pretty much whatever else you want. Law, human rights, and medical ethics reflect, transmit, and reinforce social norms. By creating mandates that are ultimately underwritten by the state's police power, certain ambiguities are eliminated and others are introduced regarding interpretation. And that, by the way, gives lawyers their jobs, so we're all very grateful for those ambiguities. According to E. Adamson Hobel, law performs 4 critical functions: defining relationships among members of society, taming naked force and directing force to the maintenance of order, the disposition of trouble cases as they arise, redefining relationships between individuals and the group as the conditions of life change. So, at whatever level of technology we're talking, and whatever level of legal formality, the neglect or violation of a legal norm will be regularly met, in threat or in fact, by the application of physical force by an individual or group authorized by society to have that force and to use it against the wrongdoer. Broadly speaking, law is a norm, plus the power to act if the norm is violated. As part of the process of identification with a social group, members will typically comply with and internalize the laws. Typically, legal norms will derive from broadly held values, and values held by those with the power to pass the laws, which of course don't always coincide with broadly held values. When values change, laws will eventually change, though the timeline can be very long, decades, even longer sometimes. If gaps arise between legal norms and social norms, there could be a lot of phenomena we know about, such as popular resistance to laws that exist on paper but are ignored in practice, laws which accord in full with popular feeling and therefore are typically effective. And it's worth keeping in mind that we're not just talking about advanced societies here. Primitive societies have laws too. They may not be written down, they may not be as formalized. There's still laws, there's still rules. People have to follow it, they don't follow them. There's going to be the use of force by the establishment and via an authorized individual, a person authorized to enforce the laws. Certain behaviors are allowed, others are not. While not all rules give rise to legal norms, all legal norms are rules. Legal norms related to a society's chosen mutilation diffuse themselves in many different levels of society and become so ingrained they can be viewed as cultural, or religious, or as Steve Scott said, mythological. then their normative character can become submerged. You don't necessarily think about it, but it's still there. And legal norms can serve to justify mutilation, to preserve it, or to change it. So in our society, particularly, I believe, we like to solve problems by cutting things out. In Australia and the US, particularly the US, episiotomy, circumcision, and cesarean sections are the most common forms of cutting. All involve the genital tract. Mutilations persist despite and because of their extreme harmfulness to the children and to society as a whole, because they're associated in complicated ways with real or imagined benefits. The rituals that various cultures develop may be socially acceptable means of processing deep-seated fears, sort of like a culture acting as a person and going through its own little psychotherapy by creating these very dysfunctional ways of behaving. We know individuals do that, but we know societies do that too. Cultures seem to institutionalize practices on children in part to promote the cultivation or preservation of desired values, or among adults, including valor, pride, bravery, fulfilling an assigned sexual role, etc. Genital mutilation is a necessarily doomed attempt to perfect a child. It's still an attempt to perfect a child. Male genital cutting and female genital cutting reframe the sexual organs. Now, the needs of the genitally modified infant aren't addressed, are they? The child basically becomes a means to society's end, which is a violation of Kantian ethics. Circumcision survives on ambiguities. We all know that. Is it medical or non-medical? Religious or non-religious? Cultural or non-cultural? Well, there's no answer, is there? Its very viability depends on living between the worlds. It's an example of a social custom whose survival requires us to suspend rational thought. Male circumcision traverses science, medicine, and religion, three of the most powerful discourses in modern society. And it involves psychological denial, parental authority, very uncomfortable issues. No wonder there's so much argument. Some of us, at least those of us who are as old as I am or older, may have gotten a little attached to our gender identity. It can feel like it anchors us from social change, from all the changes that are going on in society. And there's a transformational power of genital cutting that must be appreciated to understand why these practices continue. Genital cutting of males can take away the quote-unquote female foreskin. Genital cutting of females can take away the quote-unquote male clitoris. There's numerous tribes and groups, the Dogon and Bambara of Mali are two examples. There's also stories from Egypt and Somalia where the male and female parts are identified in such a way that cutting needs to happen to remove the parts that aren't wanted. Cultural myths and norms help establish legal interpretations. The legal status quo, where the current legal status quo, where circumcisions are not punished either criminally or civilly as long as they're done competently and with quote-unquote consent, which Zenas is going to talk about, has to be unstable. It must be an unstable status quo. It can't persist indefinitely. History is with us, long-term history. Now, how long it's going to take is a question. Is this generation going to be the last one? We hope so. We don't know. But I do not believe that the current status can continue indefinitely because it's not based on reality. It's not based on what society needs and what people need. It's based on a temporary cultural need to have these mutilations go on. As Fox and Thompson noted in Seattle, we need to move away from determinations regarding children based on welfare and best interests. Because welfare and best interests are two terms that can be twisted in whatever way you want to twist them. Just like people who say, well, circumcision can be done for medical reasons, and then all the reasons get put in as medical reasons. And when we stay with this paradigm, judges are going to be afraid to challenge the status quo. The status quo is, of course, as Chantal talked about, that male and female genital cutting is perceived quite differently. The problem is facilitated by the different terminology. We don't talk about female rape and male rape. We don't talk about female incest and male incest. And I believe that this differential terminology is an artifact of the way that we have done male circumcision and not female circumcision. So we created a terminology that privileged male circumcision and called female circumcision female genital mutilation, and made male circumcision sound very innocuous. I don't think that was an accident. And this bifurcation of terminology has continued. Many of those who deplore female genital cutting have no objection whatsoever to male genital cutting, as we also heard earlier today. And world opinion has determined that female genital cutting is improper and should be banned by law, and I certainly support that. Genital cutting is almost always defined in terms of one gender. Thus, it's almost always discriminatory. And of course, the paradigm of discrimination against men is regarded far less seriously than discrimination against women. Have I released half an hour already?
Well, we started late, and we're trying to catch up.
Well, give him a little more than that. Pour him a glass of water, too, will you? Which is what I was trying to say earlier.
I mean, it's only been 15 minutes so far.
Yeah.
Okay.
Keep
Give
going.
another 10.
He's got water. Oh, he's got water. Okay. Okay, thanks.
Today, the most striking asymmetries between male and female genital cutting lie in the fact that powerful international agencies are promoting the first as a scientifically proven health precaution while campaigning against the latter as a significant threat to health. Our own S.G.A. Brown for today, remember S.G.A. Brown was the 3/4 abnormal guy, maybe Brian Morris, writing with reference to HIV an article titled Why Circumcision is a Biomedical Imperative for the 21st Century. The UNAIDS and WHO have failed to acknowledge the well-established fact that rates of new HIV infection have been declining for over a decade as the disease comes under increased control. AIDS is not, and never will be, a critical public health problem in developed countries, where the disease remains largely confined to the traditional subcultures, gay men and intravenous drug users. For those able to obtain the needed medications, AIDS is no longer the death sentence it once was, and we're certainly not saying it's not a horrible social problem. The fact is that the issue has to be considered as a whole. As Green and Bollinger et al. Discussed in Future HIV Therapy, condoms are 95 times more cost-effective than genital cutting, stopping HIV, leaving aside all the other problems that genital cutting causes. Posing circumcision as a vaccine may make it easier to compel its adoption, and of course that's the reason why circumcision as a vaccine is being discussed. Now, as Thompson has noted, the pain is often omitted from the discussion of this issue. And as Hanni Lightfoot-Klein has discussed, there's parallel justifications for male and female circumcision. Compelling the adoption of male circumcision is exactly the goal the U.S. Centers for Disease Control is vigorously pursuing. For those who imagine the 3 randomized controlled studies in Africa were all about Africa, the dream is over. Based on recent CDC correspondence, which I just received about a day before this conference, and I had to rewrite my paper for today. Based on recent CDC correspondence, it is expected they will issue a preliminary recommendation for universal neonatal circumcision sometime within the next year. The CDC's edicts tend to be faithfully followed by U.S. doctors and hospitals. Circumcision may go the route of hepatitis B vaccines in the U.S. Now, hep B vaccines are not really a sensible thing to do to newborns because as a newborn you can't get hepatitis B. But nevertheless, hepatitis B vaccines are now given based on CDC recommendations to children when they're born. We can envision a similar scenario with circumcision. Circumcision may once again predominate among the vast majority of U.S. newborns, except for a small pocket of highly educated folks who say no. So here in Keele, I want to ask our European friends to bear this in mind and please support us and work with us actively as we try to challenge this. We really need your support, given that you come from a much saner location on this issue than we do, to help us transform this potential crisis into an opportunity to educate the world about the benefits of leaving males intact and other more cost-effective ways of combating HIV. Ideas about masculinity and femininity are deeply bound up in genital mutilations. The duality we've constructed and how we keep intersex people out of the duality because they don't quite fit in. Janice Body recently asked, why is there no outrage because these excisions are performed on boys and only girls and women figure as victims in our cultural lexicon? Outrage has already been provoked, of course, by courts' tendency to use narrow definitions of legal standing to avoid addressing issues. So it is that we've had very few cases that have squarely addressed circumcision on its merits. One of the first, and certainly already the most famous case ever, is of course Boldt versus Boldt. Now most of you know the basic facts of Boldt versus Boldt and know that there was an Oregon Supreme Court decision earlier this year in this case. So I'm going to pass on and sort of talk about some reactions to this case. Of course, what happened in Boldt versus Boldt was a non-Jewish father converted to Judaism and wanted his son circumcised, and the mother didn't. And the trial court and the intermediate court in Oregon said that, in fact, the father could compel the circumcision, and the Supreme Court said, well, no, actually, you have to consider the child's views. And astoundingly, the father then petitioned the U.S. Supreme Court for review of that, basically saying to his son, I am so uninterested in your views that I'm going to the Supreme Court to ask them to not consider them. It's exactly what he's saying. Just astounding. In the final paragraph of the court's ruling, the court said, if the trial court finds that M agrees to be circumcised, M is Misha, the court shall enter an order denying mother's motions. If, however, the trial court finds that M opposes the circumcision, it must then determine whether M's opposition to circumcision will affect father's ability to properly care for M. And if necessary, the trial court can then determine whether it is in M's best interest to retain the existing custody arrangement, whether other conditions should be imposed on father's continuing custody of M, or change custody from father to mother. A custodial parent such as Misha's father does, of course, have a well-recognized right and responsibility to make medical decisions regarding necessary medical treatment, which obviously this is not. Even if the child wants to be circumcised, the father's proxy consent should not be valid because the surgery is not necessary. Moreover, the possibility of the consent, quote-unquote, being uncoerced, is so slim as to preclude such consent as justification for the circumcision. The obvious and reasonable solution is to let Misha grow to be 18 and see what he wants to do himself. It's only a few years to go now. He was 5 years or 4.5 years now. Attorney Guy Shecker was most troubled by, quote, the gratuitous linkage of circumcision with custody. Ironically, this procedural point may be precisely what got the case under the Oregon Supreme Court docket in the first place, as family law matters are rarely, actually almost never, reviewed by courts of general jurisdiction. In fact, they're generally barred from such review. It is appalling to put the child, says Guy Shecker, in the position of choosing surgery to stay with dad or freedom from surgery with his mom. Doc asked in his amicus brief that the issues of custody and circumcision be bifurcated. And you notice in what the court said that the issues were really closely linked, and John was right, I think, in saying that was improper. Guy Shecker noted that the court mentioned only the child's right to be heard, but didn't discuss its duty to protect him. Now, to me, this case really demonstrates how poorly the law is equipped to deal with any matter requiring a step outside immediate cultural context. You know, if you've got an accident with your car, the court can deal with it. If you've got some parent being abusive in some typical way that the court understands, like hitting their kid, the court can deal with it. But if you've got something that is so deeply embedded in our culture that, you know, Maryland is so unrecognized that she can't even be recognized by the MacArthur Foundation is unrecognized, I mean, that's a real problem. I'm referring to a foundation grant she applied for a few years ago. All the Oregon Supreme Court is able to do is ask the trial court to look at the case again, this time taking into account the son's desires. One would have thought that could have been done the first time around and thereby saved countless trees, not to mention potentially a baby's foreskin. The comment by Lon Griffiths at the start of his piece on Boldt in the ARC newsletter, the last issue, pity poor Misha Boldt, he said. Couldn't help but remind me of the U.S. Supreme Court Justice Harry Blackmun's famous Poor Joshua dissent. Now, this is almost 20 years ago, but this was right when I was in law school. In this 1989 case, the Supremes voted by a margin of 6-3 to absolve Wisconsin's Winnebago County of any responsibility for Joshua DeShaney's fate. Joshua DeShaney ended up being paralyzed and profoundly retarded because he was the victim of brutal pummelings at age 4 by his father, and also the victim of social workers not doing anything despite the fact they could see there was something serious going on. Poor Joshua, Blackmun wrote, echoing Lon Griffith's poor 12-year-old Misha Boldt. Poor Joshua, victim of repeated attacks by an irresponsible, bullying, cowardly, and intemperate father, and abandoned by county officials who placed him in a dangerous predicament. It is a sad commentary upon American life and constitutional principles. And so, similarly like Joshua's case, Misha's case is a sad commentary on American life and constitutional principles. In the U.S., at least, what I like to jokingly call the wonderful world of law, has just not been able to effectively grapple with such a heavily contextual issue and heavily cultural issue as male circumcision. We just can't address it. However, there are some signs on the horizon that the times are changing. 2 months ago, I was in London, as F.U. Adorka, who frankly told the audience that she supported intactivism. The anti-FGM movement had simply made a strategic decision not to openly support intactivism, as it would make the protection of females harder for them at that point in time. And yesterday, the director of Forward basically said the same thing at a press conference that many of us here were at. So 2 prominent UK organizations that hitherto have labored on opposite gender sides of the genital integrity battlefront, Forward and Norm UK, have launched a new joint campaign promoting the right of all men and women to say no to unnecessary genital surgery. This is a landmark development. And I think it can really help move both movements forward and advance the integrity and credibility of both movements. So this is great news.
Mm-hmm.
Sally Sheldon wrote a very interesting article about FGM and cosmetic genital surgery. Cosmetic genital surgery is an interesting development that's become more popular over the last 10 years or so. And I'm sorry to say that I'm from the world capital of cosmetic genital surgery, namely Los Angeles, California. It becomes even harder for it to be defended. On the one hand, cosmetic genital surgery is okay. On the other hand, female genital cutting of any sort is not okay. And on the other hand, male circumcision is totally okay. I mean, this balancing act is just unsustainable. What we're basically doing is privileging certain practices over others. However, we may try to explain it away. We just can't do it. So what Sheldon did was she looked at 4 issues: consent, oppressiveness, injury, and offensiveness of practice, and tried to see if any one of those could distinguish cosmetic genital surgery from FGM, and she concluded no. Any legal regulation of body-altering practices must be consistent. In addition, if restrictions are to be imposed, they should be constructed according to valid health concerns and should treat the practices according to the risks involved, rather than merely enforcing dominant notions of the acceptable body. So I think one thing that the FGM movement has done, and I don't think it's been deliberate, but there's been a process of exoticization, if that's a word, of making exotic FGM, contrasted with culturally, first world culturally, I think male circumcision is normalized. So we've got a practice that's, we've got an almost missionary evangelism, which I support, but a missionary evangelism against FGM, which is permitted because it isn't culturally, our culture isn't invested in preserving FGM. And then there's a culturally inert prurience, I think is a good way to look at it, regarding male circumcision that reinforces the status quo. And our old friend law helps both processes by reifying and establishing and reinforcing social norms. So law comes in and basically says, everything you folks are doing is right, and here's the penalties for this, and here's why this is okay. Circumcision is so cool and groovy that, in fact, we're going to exempt rabbis in certain states from laws that would otherwise criminalize their actions, because we want to make sure there's no problem at all with male circumcision. In a recent article by famed author Erica Jong, bringing together many issues we've talked about today, mythology, doublethink, cultural inertia, a mother, Erica Jong, famous novelist, lays out her numerous misgivings about circumcision, but nevertheless, in the end, with no explanation whatsoever, she allows her son's circumcision to proceed against her own instincts. "Don't mark him," she says. "I wanted to shout. Don't mark him," I wanted to shout. But instead I laughed hysterically at all the Moyle's jokes. Remember the joke Chantal talked about? We cannot help but note John's fascinating yet chilling mention of hysteria, hysterical, a word that is etymologically and subconsciously related to hysterectomy, itself another excision of a sexual organ to solve a perceived social problem, and a procedure that is often unnecessary. The truth does come out in the end, and I do believe we have time on our side in the end. Regardless of the efforts of those who would keep it in, sooner or later the truth comes out. I thank each one of you from the bottom of my heart, and I sincerely mean that, for your efforts to spread the truth and save the children. Thank you.